All right, so my name is Christine Taylor. I'm an attorney at the Town Law Firm. Today I am pinch hitting as IT, if you will. If you have not attended one of our Zoom webinars in the past, I'm just going to run through some parameters with you right now before we get to the nitty gritty and what you're really here for. So with the Zoom webinar, we have our panelists who will be speaking. As you can probably see on your screen, our panelist Mark has already shared his PowerPoint, so you will see that. As he is speaking, if you have any questions, if you hover over that screen, you'll see on the bottom that a bunch of icons show up. You will see the one that says Q&A. You can open that and you can type your questions in there. Kate, our marketing director, will be moderating them, so that way she can shoot them over to Mark as we progress through this. So you use that Q&A feature down there, so that way you don't have to hold your questions to the end. You can put them in there as you think of them, and we will answer them live. So if you have any issues with that, there is the ability on your menu on the side where your name is, where you can raise your hand. So if you click that button, it will show a raised hand. And when we take questions at the end, we can always unmute you if necessary, if you couldn't figure out the Q&A feature. But please utilize that Q&A feature at the bottom so we can get your question answered as quickly as possible. I am now going to pass it over to Jim Town, who will do our introduction for this meeting.
Good afternoon, everybody. Thanks for joining us. The genesis of this program is quite simple. It's FCA's recent pressure on dealers to enter into the data exchange agreement. It's master data exchange agreement. And having had several clients ask me to assess what the benefits and burdens of the agreement were, it reminded me that there's been a continuing pressure on, as we all know, the protection of customer data information and how that's held and with released and to whom it's released. Going back a bit, I've had a number of conversations with dealers over the years on things such as employees in the front end using their personal email address to scan a sales contract, transmit it to the bank, whatever, and discussed obviously the issue of protecting the consumer data, because clearly if you have a salesperson transmitting data on their Yahoo account, you've got a problem. Dealers struggle with this. A number of dealers, I've tried to talk to you about setting up your own email server and having very strict guidelines for using only company emails. That's going to be their first line of defense. But when the master dealer agreement came through from FCA, it's a challenging agreement. I know most of you are pressured into entering into it, and I understand that pressure from the factory. But there are issues that are involved in this particular agreement that you need to be aware of, not the least of which is you're being expected to upload all kinds of consumer data for alleged analysis by FCA, and they promise at some point in the future to have the infrastructure in place to provide the leads and sales generation benefit that they've represented you'll be getting. That in itself was concerning to me, but there are a lot of other issues. We have, luckily in our law firm, terrific association with an attorney, Mark Roman, who teaches data protection, among other things, at Albany Law School. But he's also got quite an extensive background. Before he went to law school, he was in the IT world for a number of years, has more certifications than the alphabet has letters. And so I thought I'd turn this over to Mark because he can teach you all kinds of things that you need to be aware of and give you some pointers on how to avoid problems. As you may know, there have been substantial claims against car dealers in the last 5 years for misuse of information, which Mark will be going into. So sit back and listen and hopefully learn a lot. Have a good day.
Excellent. Excellent. Well, welcome. Good afternoon. Hope everybody's doing well, digging out after our recent nor'easter. This is a topic that is very timely, and the urgency really can't be overstated in terms of some of the core principles here. I've put together a little presentation, a short presentation having to do with auto dealership concerns in information security and some of the more prevalent risks that you guys should be probably aware of at this point. In fact, I'm sure many of you are, in terms of what you have to deal with in order to compete in today's market and be safe and protect the data of your clients, your customers, as well as preserve the integrity of your own business. So there's a lot of good stuff here, and I'm gonna touch lightly on some of the topics just to give you an overview. Other things I'm going to dive down in a little bit more detail just to give you something you can take away from this webinar. So I assume all of you can see the presentation. Without further ado, I'm going to start moving through this. Any questions at any time, please use the raise my hand button or the notification button, and we'll jump in with your question. Otherwise, I'll pause at regular intervals and see if there's anything I can assist with at that time. Okay, so moving right along here, we're on the presentation and I'm on screen 2. So here what I'm talking about is why are privacy and data protection controls important? So this is the question of the day. Really, the number one thing, let's talk about protecting your business. Without the business, none of these other things really matter, right? So we want to protect your business. We want to make sure you know what it is you have to do when and if you collect consumer data. And of course, that's inevitable in the work that you're doing. So really maintaining a secure, safe, and reputable business is, at the end of the day, our goal to help you. And that should be, of course, something you're thinking about as well in order to preserve your business over time. And also to ensure that going forward, you'll be positioned to accommodate future regulation, restrictions, or requests. Couple of things here I want to touch on, and I'm not going to get into this too much in detail. I'm sure many of you have seen other security presentations having to do with regulatory compliance. A lot of times it's beaten to death, and it becomes sort of a background noise. There are some things I want you to be aware of, though. Generally speaking, regulatory compliance becomes a major component of what your compliance program needs to deal with in this day and age. So we talk about privacy, of course, and how the consumer is protected. The government now has a substantial interest in that. So it's important for you to understand some of the buzzwords in terms of the actual statutes, whether they're federal or state, so that at least when you're dealing with, of course, us in terms of an advisory capacity, or if you have an on-site staff, you can ask them, how you're faring in terms of a scorecard, in terms of maintaining compliance with some of these actual statutes. Regulatory compliance, a lot of it at the federal level is going to really fall back to the FTC Act Section 5. Really has to do, all you really need to think about, unfair and deceptive acts or practices with regard to your trade. So that's actually the blanket statement that they use to enforce the majority of their actions. Most of what they do is, in terms of investigation, is look at your firm. Was a client or a consumer unfairly exposed to a data practice, such as a breach? You didn't adequately protect the data as you reasonably should have, and therefore they're going to take action, most of the time resulting in what we call consent decrees, in which case you'll be forced to employ certain corrective actions and or pay a fine. So it's not a fun process, and the FTC Act Section 5 is really what gives the entire federal government the majority of their teeth to bite down on privacy practices at this point. I also, of course, want you to know, and this is sensible, you want to limit breaches and lawsuits. Lawsuits can be criminal, frankly, and civil. There could be a criminal suit against you brought by an attorney general. And of course, clients or consumers have the right in certain cases to bring their own lawsuits for the inappropriate use of data, or that includes, of course, unauthorized use. So I'm just going to move quick, and I'm not going to belabor the point here. Oh, was there a question? I'm sorry.
We have a hand raised, so we'll unmute that person so they can speak and ask their question.
Excellent.
Chris, there you go, Robert. I think your mic is off. There you go.
I'm good right now. I couldn't find the PowerPoint, but I was able to find it, so I'm on board right now. Thank you. Sorry to stop your.
You got it. No problem. All right.
Your speech. Thanks.
No problem. Thanks, Robert. So just again, to hit some of the high points that you as dealers are probably subject to dealing with on a day-to-day basis. We talk about the Fair Credit Reporting Act, the FACRA, the FACTA. Really what we're dealing with here is data that you're collecting in terms of being able to process credit reports so that you can get to a CRA, a credit reporting agency, to try to determine financing. Right, so here you might be collecting things like personal information, of course, right? Social security number, address, job history, an applicant's credit history, account details, inquiries. any of these things that go to collections or collection account information that you receive. I know this is the day-to-day sort of lifeblood of a financing department, right? So this falls squarely under the FACRA and the FACTA federal laws. And you guys, I'm sure, are well aware of this. You know, the thing here is I want to show that this is the type of data. It's sort of the bread and butter of the daily work of these departments. This all needs to be protected, and there are significant ramifications in terms of fines if they're not. In fact, what I have here is a quick summary. For FACRA, you could be held for any kind of proven or at least agreed to violation, you know, up to $4,000 per violation. A lot of times it's not going to be one record for one consumer. It's going to be a breach of, you know, tens, hundreds, or even thousands of people that got breached. So per violation, it could be a multiplier here that really becomes economically damaging. FACTA, we also talk about another 2,500, and for the state, they could bring their own action for potentially up to $1,000 or so per violation there as well. So again, it's critical, and this is the bottom line. If you're doing that sort of credit reporting information run where you're trying to determine if somebody's eligible to get a loan for a vehicle, that data needs to be protected, and frankly, the whole conduit to the credit reporting agency to get the report. So the whole process needs to be subject to a data security program, as I write here, to prevent any of these FACRA or FACTA violations, okay? What I have here too is the Gramm-Leach-Bliley Act. This actually has to do with maintaining the technical security safeguards, the administrative safeguards, physical safeguards, in order to protect the security, integrity, and availability of information by customers that they give to you and for customers after they do. You are considered financial institutions as a dealer, and as the statute reads, it's if you're significantly engaged in providing financial products or services. And again, just quick summary, it varies, of course, based on circumstance, reasonableness, et cetera. There are multiple factors. Can include fines up to $100,000 per violation. There can be personal liability for officers and directors of a dealer, okay, of up to $10,000 per violation. And criminal penalties, they speak for themselves: loss of liberty, up to 5 years in prison, and you could lose the licenses of your business. So important stuff to keep in mind, all right? And I do want to just point out, this is kind of a tricky area to navigate. It's best sometimes to view the data that you're collecting as all sensitive. Data classification is something that we get into from a security perspective, and we can do that. We can assist that process from town here as far as a service that we provide. But classifying the data, knowing what to protect, is half the battle. Most of the time, I think a general approach I see is that most people treat all data as if it's sensitive, unless it's been specifically de-identified or anonymized. And in the case of a dealership, that's really not going to happen very often. So treat all the data that you collect as critical, or as we say sometimes in the security industry, treat it as hot or radioactive. It's dangerous data. You don't want it to get out. You don't want it to be exposed. You don't want to expose anybody to it that doesn't need to get to it. Okay, so it is important, and some of the nuances of these statutes make it difficult if you try to, you know, pick and choose which data to protect and whether or not that would qualify for a protection or not. Okay, I do want to back up quick. I had a slide here for recent frauds against dealers. I wanted to show you a couple of ways by which data could be, as we say in the industry, exfiltrated or unauthorized distributed in an unauthorized way. Okay, just quick, a few case studies here. Recently, a cyber thief had actually netted about $253,000 by intercepting a wire transfer between an exotic car retailer and another dealership. Never any recovery of the money, so it was just a loss. Not sure if that was claimed under insurance, but more than likely the dealer just had to absorb it. How did that happen? As I put in red here, simple: employee clicked on a phishing link and provided information to a bad actor, and it enabled them to modify the terms of the wire transfers with the bank, and the money just went to the bad actor and was never seen again. This does happen quite frequently. As Jim mentioned earlier, we want to prevent people, staff, or otherwise folks in the chain of the data transmission to be using any kind of personal accounts. Certainly, we don't want anyone to take data home with them or use it in any way that could be unmeasured or untracked without being logged. This is a great example. Once that parameter was modified, the dealer didn't know what was going on until the bad event happened and the money was lost. If you keep all of your transmission and communications in-house under dealer-controlled systems and circumstances under the dealer program, you're normally going to prevent the majority, if not all of these, from happening. Okay, so vigilance is very important here. Second example, cyber criminal gained access to a dealership finance an insurance employee's computer and downloaded 200 customer credit reports from a credit bureau. So again, we were just talking about FACA and FACTA. This becomes a real problem. How did this happen? Somebody, again, brought in malware. It was probably phishing. And again, phishing is where you get an email that looks like it's from someone, but it's really from a bad actor. It's somebody you can't trust. It's designed to look like you can. So it's a way of fooling you. So keylogger malware was installed on that particular staff's PC. And when they typed in their password and credentials, they were actually captured, posted to a web page for the bad actor. And they were then able to log into the appropriate systems and capture that information. Of course, all inappropriate, and it caused considerable liability. After all the dust settled, it cost the dealer about $150,000 to put that issue to rest. And of course, you know, you've got the financial liability, but then of course you're dealing with reputational damage too. So this, of course, makes the news. People read about it. Regionally, people read about it, and it becomes an issue in terms of restoring your standing in the community as a trusted commercial entity. So let me just follow this up. This was a larger breach that had to do with more of a dealer management system. It was a system called Dealer Built. In 2016, Dealer Built themselves was actually breached at about 12.5 million customers. Doing business with 130 dealers. Information was just lost. It was pulled. How did that happen? Well, that was interesting because at the back office of Dealer Built, probably an authorized staff took a portable flash drive or some external media and plugged it into their backup network with a copy of the database. So unencrypted, not protected, not monitored or managed. Nobody knew about it, so it wasn't authorized. And it was actually exploited eventually through some network breach that occurred. Typically what a hacker is going to do is scan the local network, see what they can see. Anything they can find, they're going to try to exploit, and they found this drive. And on this drive was a database, which they very easily pulled out of the network of the dealer to their location. And at that point, the data was basically made public on the internet. So for 18 months, by the way, that drive sat there. And that's a great example of not having appropriate physical and logical controls to identify those things and, of course, prevent them from happening in the first place. So I'm going to move on to actually the case study that I'm using for this presentation. Before I do, are there any questions at this point regarding the statutes or some of the examples that I've already described? Just want to give it a minute in case anybody has any questions or clarifications required. So if not, I'll keep on moving here. So contracts, we did see this recently. So FCA, which is the one I'm going to actually pick on in this presentation, has pushed out some material to some of these regional dealers that we're working with, including a lot of you online today. It's not just Fiat Chrysler, though. You can see here between the big dealers and the manufacturers, Ford, GM, some of the exotics, of course, Audi, Mazda. So, again, some of these are not just domestic. They're going to have European headquarters. They're going to have a global presence, of course. So this actually becomes an interesting case study, and I'm going to dive into the FCA agreement now. But this is a pretty vast sort of emerging almost area of focus that we have right now. Okay. A data exchange and usage agreement, by the way, is the means by which you agree to protect the data and vice versa. So just a little bit of, I'm not going to read through all of this, but as I mentioned, FCA is, of course, a large company. It's an Italian-American, world's 8th largest dealer, domiciled in Amsterdam, major brands. So this is not just a regional. This is a large global company. And there are many, many restrictions now around how data should be protected based on who they are and how you're working with them. Okay, so a global dealer, obviously, manufacturer, lots of brands. Again, some of the exotics, Maserati, Abarth, operating in all the global markets. So when you start working with them, and you are working with them, of course, you're dealing with potential areas of the globe that have various privacy requirements. I'm kind of taking this a little bit to the macro now, so you get a sense of the scope of this. But you got North America, of course, Latin America, Asia Pacific, and Europe, different privacy regulations throughout those areas and regions. All right, so it's extensive. And why would you do this? Just as, of course, this is what they're saying. They're going to share data with you to help with your marketing, quality improvement efforts. And then you'll basically reciprocate and provide data to them to give them some sort of quality control or help them ostensibly better position their data to help sales, essentially, and marketing, and just the success of the dealer and the manufacturer overall. So it sounds great. Obviously we want to get involved with things like that, especially if there's no additional upfront costs. Why wouldn't we, right? So what's the catch? Seems like it's easy to do. All you have to do is sign on the dotted line. The FCA, which we specifically were reviewing for terms, includes significant privacy and data protection requirements for you as dealers. So you sign on the dotted line and you start the relationship. Now you have to remember you've actually signed up to do multiple things. So I'm going to just step through a couple of these areas to give you a sense of it, starting with compliance with laws. But obviously they're talking about security and privacy program, consumer requests, handling and management, your own dealership privacy policy, and how security incidents would be handled. All right, so just quick, all right, unless there are any questions, I'll jump into compliance with laws. This is an interesting framework that they've presented. This is a lot to bite off. Each dealer, and I'm just going to read this particular language because this is very, very broad. So what are the laws? You're saying you will comply with all applicable, okay, present or future that you don't even know about yet, local, state, federal, or international law, statute, rule, regulation, code, ordinance, court order, compulsory process, decision, treaty, judgment, or now not laws, industry guidelines, including industry self-regulatory guidelines. Something like that would be, say, for instance, PCI DSS, and principles for any applicable jurisdiction. So just about every possible data protection measure is included here. All right, so what's important to know? So if we treat all of the data like it's sensitive, like I mentioned earlier, there may be a slightly higher cost in doing that. But generally speaking, if you do that and you have an appropriate program in place that's essentially industry recognized and promulgated throughout the commercial entities, you'll see compliance with the majority of anything that this specifies here. It's important to realize that you're not just trying to satisfy a New York law or PCI DSS. You're potentially looking at things you don't even know about yet. So being proactive is going to be very important in order to protect the data. Otherwise, you may have to retrofit a program onto something you already have at the expense of many tens of thousands of dollars, and sometimes even more, depending on the tools you may have to implement. So compliance with laws. Keep in mind, not a small paragraph here. This is very broad and very inclusive of just about anything that you could be working with Fiat Chrysler. Okay, so a security and privacy program, that's kind of the nuts and bolts of how we protect data, right? So what you have to do under the Fiat Chrysler contract is establish and maintain a formal, written, company-wide information security and privacy program. This is actually not specific to FCA. You should be doing this anyway with regard to some of the New York State requirements. And in fact, good business practice would demand that as well. And so you should have security policies, privacy policies. So they are two different things, and privacy and security standards and procedures. All right, so they have to, and they should be appropriate to the size of your organization. If you were a small dealer, you know, a couple of employees, the data is still important. You have to protect that. Again, protect it all like it's all basically hot, you know, radioactive data, but it doesn't need to be an enterprise scale program that's costing several $100,000 a year to maintain. It just requires the due diligence and the reasonableness that is required under the law, really. So this is something that we can help with extensively. I've worked with this for many, many years. There are many frameworks, but we tend to focus now on NIST. NIST is really a federal standard that's been retread for consumer and commercial purposes in the United States. So there are some great privacy frameworks that they've just implemented, and of course, some traditional security frameworks that can be tailored for your organization to help you develop those policies, procedures, methodologies. And that, of course, involves employing controls. Once we actually put controls in place, they need to be tailored for your organization over time, but of course, monitored and managed. And that's, again, things that we work with and things that are going to actually prevent you from running afoul of any statute, law, or incident, let's say. You know, they're looking, of course, for this to be basically all-inclusive, holistic across your organization. How are you accessing, using, transmitting, storing, or processing FCA data? They want their data controlled. You want your data controlled as well, without question. So it has to be a written policy. You basically have to have at least a maturity that meets the scope and scale of your organization's use of the data. Okay, so I won't belabor the point. There's a lot there, and I'll talk a little bit later on about some additional things. Any questions at this point? Feel free, let us know. I'd be happy to take a moment to address anything. Consumer requests. So again, we're talking about, again, the FCA requirements. Each dealer, so now you guys, as dealers, shall be responsible for responding to and processing consumer requests as required by the DPLs that apply to you, which is just about everything, right? As we talked about earlier. So what they're doing there is they're burden shifting. So they're basically making it your requirement to manage the data that you have, and that any data that you have provided by FCA, you also need to protect and use in an authorized manner, so to speak. And you also need to provide reasonable assistance to FCA, an enormous company, and they would probably loop you in if there were any things that came up related to the use of the regional data you were providing. And of course, as they would need to respond, you would be looped into that. So you would want to be able to demonstrate control and compliance over that data, especially at that time. More than likely, you'd be in front of an arbitrator or some sort of magistrate at that point, and it could be federal, state, or even European, depending on the nature of the issue. So you don't want to be playing catch up at the last minute, certainly if something like that was to arise. Privacy policy. You should have, there's basically two approaches to this. You should have a publicly accessible privacy policy that talks about what data you collect and why you use it. Now that's going to be a little bit different from the data that you are collecting for, say, credit applications. There should be just something, a dealership-wide general approach that customers can look at in terms of them getting a sense of how you protect their data, how you submit it, or rather how it's used by you, or how they get it to you and for what purpose. Some things may vary there. Again, under the FCRA, the FACTA, a little bit of different requirement there. But here you're going to talk about just the dealership's awareness of consumer data and how you're going to protect it. And it'll be something that's able to be disclosed publicly. Now, the second bullet that I have here, ensure that all individuals whose personal information is provided to FCA by you. So if you provide any personal or personally identifying information to FCA, you're basically saying the consumer has consented to this. And that may be actually a fairly bigger ask than you think. It depends on what your data collection process looks like as to whether or not that's inherent in the process now or not. Consent is a big issue. It's not actually as prevalent in the financial industry as it is in the protected health information world, where we're dealing with health information. But it is definitely, nonetheless, especially under the Gramps-Bliley Act, consent and use of personal data is important to understand. So again, depending on what you send to FCA, you're basically telling them that you have received approval from the consumer. All right. And whether or not that's an easy lift for you, of course, is dependent on your organization. Some have probably thought this through, others may not have. And it's just something you should keep in mind. Again, not just with the FCA contract, all of these manufacturing organization DUAs or data exchange agreements are going to have a component like this. So keep this in mind as well, privacy policy issues. All right, and security incidents. So now let's say the worst thing happens, you have some kind of security incident. It actually turns out to be an incident where data may have been inappropriately exposed or lost, or a system was compromised in some way. Well, if anything involves FCA data, now you need to notify FCA. This is basically a breach notification requirement. You need to share everything with FCA. They get in bed with all this, take all appropriate corrective actions. All of that's at your cost, okay? And so basically, you're also going to coordinate with them prior to communicating. All right, so a file, a communication, a notice, a press release, or any report involving a security incident around FCA data, they're with you on that. They want to partner with you on that. So you become involved with them. There are expenses involved with this, and also your loss of autonomy. So things become more public. They have requirements in terms of what they need to share. And so you're going to be involved with probably being on the front line of paying for remediation, breach notification to consumers, and potentially providing credit notification services for a period of time, ranging anywhere from a year to 5 years, depending on some of the specifics of the case or the incident. We see with the FTC under the federal United States law, the Section 5 we were talking about earlier, a lot of times that goes for 5 years. So let's say you had 10,000 consumers, or let's make it smaller. Let's make it 5,000 customers that were compromised. For 5 years, you'd be paying for consumer credit report protection for them. As an example. Okay, so security incidents. So you've got a lot going on here. So if you're going to get into something like this with the FCA, okay, how can you comply? And a lot of you guys hopefully have already thought about this. You know, this changes. It's funny, I've got a copy of this NIST SP 853, and this sounds very technical, and it is very nuanced, but there are a lot of common sense things here, but these change over time. So a new version just came out, and it's a bit different than it was when the last version came out about 3-4 years ago. Having somebody aware of those changes is going to enable you to stay right in the front of the compliance wave, and you will be sure to capture all of the changes and nuances that are expected of you. But it is tricky, and it's not exactly an easy walkthrough. You got 18 specific security control families. The documentation is hundreds of pages. And then there's a real world implementation component of it as well. A lot of times it's not really obvious what they're asking you to do. So if you follow a framework that follows 853, you're going to have to spend some time on it. Or, of course, we have experience looking at all of this. And I implement written information security programs frequently for commercial entities, state entities, et cetera. It is really one of those things where you want to have some real world background on this instead of just jumping in cold. And then you also have SB 800-171, which I just mentioned here. It's actually a little bit outdated now. It's a smaller subset. NIST had released that specifically for commercial entities. But again, it's a subset. Instead of 400 controls, it's about 203 controls. But it really, everything always depends on the scope of the organization and what you specifically need. What data do you have? What business are you in? What compliance requirements do you have? And that will help dictate your written information security plan and program. Okay, just quick for an orientation, these are some of the subject areas of the 853 framework. Again, NIST is just one of several. You could be looking at ISO 27001, for instance, but more than likely, I would recommend NIST. And these are the different areas you'd be looking at. A lot of this is network security related, but you do get into areas where you're making changes to systems. Number 10, I can't overstate number 10 enough, personnel security. That has to do with everything, the entire employee life cycle, onboarding, frankly, on resume gathering, onboarding, provisioning of access, maintenance of access, recertification of access, transfers. So if they get promoted, they might gain access, they may need to lose other access. And then ultimately, if it happens, and I understand there's a fairly significant issue with this, with high turnover entities, the termination of staff, and how do we close up access behind them? If we don't do that, that actually creates an enormous backdoor vulnerability that's very difficult to defend in a case or some kind of action where you're trying to talk to the state or a court about whether or not an action was reasonable. It's not deemed reasonable to leave open accounts for terminated employees that could still connect to the network or share their credentials with someone else. And then if a data incident or a security incident results, you basically just had a breakdown of whatever your plan was. We want to prevent that from happening at all costs. So number 10, I can't really overstate enough. Lots of good stuff here. Each one of these slides I could talk about for an hour by itself. So here's the subset under 171. So it's basically a lot of the same thing. You'll see personnel security is still here on point 9. Okay, lots of information here. This is just for your takeaway and awareness. So again, how can these frameworks help? Well, you got a lot of challenges. You got the FCA data privacy case study we just did. It applies to all the data use agreements, data exchange agreements that you might enter into. You're going to want a security privacy program. Dealer software licensing, believe it or not, that's an issue. If you don't keep an inventory of your software licenses, you can be found in non-compliance and you can run afoul of some of the software laws, essentially. And if you are in non-compliance, that can result in significant fines and what we call a true-up, where you actually remove old licenses or buy and install new licenses. It may be an unexpected expense if you're not keeping an inventory of those things. So again, the information security and privacy program will help you track an inventory of your software. Of course, the program will assist with cybersecurity and breaches. Critical, as I mentioned, that personnel security, ongoing staff security training, specifically for phishing. We don't want people clicking on links. We don't want people bringing in any malware, web links that are potentially risky. We don't want people posting information through emails about particular accounts that they access on the credit reporting agency site, for instance. You have to be very careful. So in the first line of defense, this is really, they call it almost the human firewall. Staff are the #1 risk right now. It's not even malicious staff. It's just staff that make choices that wind up putting the organization at risk. Okay. IT systems resiliency. If you have a program, you're going to have documentation. And if you lose a trusted staff member, let's say you have a guy who's your IT admin and he leaves. He had all the passwords. He set everything up. He knew everything about it. If you don't have the documentation, the logging, the documentation for auditing purposes, you may be at a disadvantage for quite a while until somebody can come in and figure out what happened. And during that time, you're in increased risk mode. So systems resiliency, very critical. It's the business continuity. at its essence. I'm just going to stop for quick questions if anybody's got anything. I don't know if Christine or Kate, you had anything, or Jim, if you wanted to weigh in on anything at this point. I'll keep moving through, but we're making some good time here. All right. I'm going to keep on rolling into some other considerations. Let's get this here. Okay. So we're all in New York here at Town Law at the moment. We do have offices in different states, but I'm going to focus on some of the New York State laws that are critical if you're working with New York citizens, essentially anybody in New York that you're dealing with a New York residency. So the DFS 23 NYC RR 500, long story short, if you have any kind of insurance license through New York State, you're covered under this statute. It's designed to require each company, as I write here, to assess your specific risk profiles, specifically information and cybersecurity risk, and design a program that addresses those risks in a robust fashion. It's not a joke. It's very strong, actually, and you need to recertify it every year. So these are some New York examples of statutes actually that are going to require you to have a program that's compliant with something like the NIST 853 framework we just stepped through. Okay, the New York State Shield Act, fairly recent changes to this. So breach definition was expanded. Private information, the definition of what private information is was expanded under New York State law. An example would be now it includes bank accounts, bank account numbers, anything that's identifying in terms of that plus one could get them to exploit a resource for an individual. So banking information, credit card information, of course, but really expanding the definition so that anything that's reasonably related, that's not de-identified to an individual is covered. And if that gets exposed in an unauthorized way, and that doesn't necessarily mean it was stolen. It could mean that it was just viewed, okay, by an unauthorized source or subject. So again, I want to point out that it's not just digital information, which, electronic information on your network. If you have data on your desktops, actually on your desks, like say a folder for a customer, and it's got information for that customer, you're going to want to keep that protected from other customers seeing that. If somebody sees some piece of information, just seeing it alone is actually considered unauthorized access. All right, so you want to keep data information secured at all times and under the custody of an authorized individual. So if you have a salesperson and that person's doing multiple deals at the same time, they should make sure that other customers aren't cross-viewing information for other people. Okay, it's kind of a must-do right now. And that data, if it's actually physical paper information, of course, it should be kept in locked filing cabinets with restricted keys at all times. Okay. So kind of nearing the end here. I know we've got about 13 minutes left to the hour. I put this slide in. This actually was a great slide I saw from National Association of Dealers. And this has to do with really all the different areas that data could be coming from or that are involved with a dealership. It really just goes to showing the complexity of the organizations that you guys are in. These concepts apply to other commercial entities as well. But for dealerships, I think there are particular complexities. And you can see here's a great example of how the dealer is working with a customer over to the far right, and all the different systems that are involved. And it may have to do with some sort of income stream, but you've got in that center sort of a dealer management system and a dealer communication system that gets you to the manufacturers. The big data, big data is basically just large amounts of data. And a lot of times it may not even be classified yet. That's why if you have that sort of overarching protection over all of the data that you collect, and again, the classic is don't collect it if you can't protect it. All right. It really is important. If you collect it, you're responsible for it. And frankly, if you've collected it, you should have a destruction plan for it, so you don't keep it perpetually. So you can stop worrying about it if you destroy it. Of course, there are statutory restrictions for some of it. You can't just destroy it, offhand. But you should keep in mind, if you collect it, you should protect it, and frankly, you should destroy it after a certain period of time. And each dealer needs to make that decision based on statutory requirements or business needs. Okay, so significant issues here. I actually look at also that's the box, one of the boxes to the right, telematics aggregators. So again, I think that's a big question in the industry right now. What kind of telematics data usages are going to be in play? And for all the data that's collected in these areas, how much of it would you submit to FCA or Fiat or Hyundai? It depends, right? Are you just going to give it to them the way you collect it, or are you going to de-identify it or aggregate it in some way? It depends. And everybody's different. Each dealership is different. There are some commonalities though, and that's how these frameworks can help you find a level playing field.
Hey, Mark, we have a question.
Yes.
So something that someone asked was, what about vendors that the dealerships are doing business with, and how can they make sure that they're secure? So who is responsible for the customer data if that becomes compromised by a vendor? Where does it go from there?
Sure. Well, this is typical, relationships. I don't know if there was actually an output for that. You got website providers on this slide that I'm showing here. That's a great example of a third party. So third party vendor management. Really the recommendation is you vet your vendors. Now, it may be that they have some standard paperwork that they can provide to you with regard to, say, an SSA 16, SOC 1, SOC 2, or SOC 3 audit that they have at their site. They provide that to you, and then that would give you assurance that their systems are tested. These are audit standards that you could rely on, say, a KPMG or a PwC to do for them, that they would pay for and provide to you to show that their systems are compliant with generally accepted principles. Okay. If you're getting into a relationship with a third-party vendor, it may be something where if it's something where they want to do business with you, you might get into what's called a vendor security assessment questionnaire. All right. And you'd have them fill something out for you that relates to framework-related questions. How are they implementing data security controls? How are they implementing physical security controls? So that's definitely a major aspect of tying up your loose ends. So your company itself is something you can control. You may need to outsource something, but you should, when you do outsource, ask for evidence that they have controls on their end, or have them provide some sort of actual evidence to you as you see fit or reasonable to demonstrate that. If you do that, and there's some sort of breach on their end, let's say, yes, you may not be able to completely shift liability to them, but at the very least, you'd be found to have acted reasonably. And typically, at least under government penalties, the penalty structure would be much less if you're acting reasonably with that kind of due diligence. Okay. So hopefully that addresses that. That's a whole other area as well. Third-party vendor management is actually a discipline under the NIST 853 framework as well. It actually shows up in those workbook areas. So you'd be covering it there if you did employ something like that. Okay. So moving on to this slide, again, just to show there's different types of inputs. You can see they show locks in different areas here. And I just thought this was a great slide. It shows that between all these different layers, there needs to be, it's almost like they're trying to represent firewalls here with security. So everything's behind some firewall, some security layer at some point. Okay. And of course you would have maybe those DCM systems where you're communicating to the manufacturers, or let's say an FCA for specific data exchange. There should be a layer there too that's providing that type of data security assurance. We're building back to what? Business continuity, resiliency, risk management. There's different layers to this. Okay, and this is a great example sort of a graphic of how these systems interrelate. So what do I have here? Really, my last slide. I just wanted to talk about this. These are common statistics now. We know these things. 59% of consumers choose dealerships based on reputation. So that could be, they got a great deal, but it also could be they know that they have trusted advisors there, and they know that they're working with people that are, running a, straight compliant type business under New York state law, let's say, and they feel confident that the business is being handled appropriately. If in fact there is some sort of incident or some kind of publicly presented cybersecurity breach, 84% of people, according to certain surveys, show that people will not return to that dealership. So the stakes are high. Even if your penalties would be relatively low as a result of that incident, obviously the loss of income, the loss of potential income and sales going forward could be really unmeasurable and extensive if in fact there was something that occurred due to a lapse in a security program. So we can help you with this. We can help you assess your current practices. We can make recommendations, of course, for how to get you where you need to be. And we're happy to provide those services as needed. So I think that's the last
do have
part of
a-
my.
I have a couple of comments in closing, Mark, if I could.
Sure.
Because of the nature of our firm's practice having the privilege of representing a number of dealers, unfortunately, we've seen a lot of the worst practices and what they result in. In the last 5 years, we've had at least a half a dozen cases involving employee thefts, misappropriation of dealerships' information, theft of trade secrets, et cetera. And in every single one of these cases, the defense is very clearly, I gave a lot of people access to my credentials. I'm the assistant manager. I'm not there 7 days a week. They needed this, they needed that, so I had open credentials. Just as Mark indicated, that's the kiss of death. You can't give or allow people to have open credentials, and you can't allow for their convenience that the assistant sales manager wants to go to lunch instead of helping complete a transaction in the F&I department. Too many circumstances of this happening. The damage to your reputation is incalculable. The real issue is whether or not you spend the time, the energy, and the finances to protect your business as best you can. On January 21st of this year, next year, we should all anticipate that things are going to change dramatically in connection with consumer protection and regulations. Whether you're in favor of that or against it is really irrelevant to the fact that it clearly is going to change. How the FTC interprets unfair and deceptive trade practices is going to be completely different in interpretation on January 21st than it is going to be on January 19th. So you might as well get prepared for the worst and anticipate that by putting in place simple things such as cybersecurity insurance and periodic reviews and enforcement of your policies and practices so that you can, if faced with a government audit investigation, show them what you have been doing. Nothing irritates a government investigator more than being told, really, I didn't know that. They expect you to know it. What gets you off the hook somewhat with respect to penalties and fines is the fact that you made a good faith effort. The federal government, as you know, or may not know, got hacked seriously, allegedly by Russians attacking the Treasury Department and every other department apparently in the government, as well as private industry. So clearly, hacking and access unlawful to your data information, it's never going to be a pure prophylactic. There's nothing you can do other than don't connect to the internet, which of course is not going to be happening. So what do you do to show that you've made a good faith effort? The things that Mark's been talking about, audits, putting insurance in place, strict policies and procedures, periodic review with your staff and employees and people. When you hear something like Bob let me use his credentials, that needs to be reported to somebody because somebody's got to stop it. Again, it's a tough situation defending a claim that the employee allowed everybody to do it and everybody knew it. The owner knew it, everybody knew it. And it really makes things difficult whether you're dealing with litigation or whether you're dealing with a government enforcer. So look very carefully at what policies you have in place and what needs to be done to protect you. I boil everything down to how many vehicles do you have to sell? in order to cover whatever expense it is, whether it's a cybersecurity policy, they cost you $20,000. And let's say you're doing $1,500 gross per copy. How many cars do you have to sell? Well, that's a certain number. How many cars do you have to sell if you're paying a fine that's 5 or 10 or 15 times what it would have paid to put the prophylactic protection in place ahead of time rather than dealing with it later on? I understand that it's very difficult. The financial burdens of running a dealership are significant. Your cash demands are significant. So looking for areas where you can save money, this, quite frankly, is not one of them. This is the ultimate penny wise and pound foolish location for you can wind up really regretting cutting corners. So that's what we're trying to accomplish today, is to give you some eye-opening with respect to the issues that are happening and the fact that with the change in administrations coming on, we all need to anticipate that the government's going to be more involved in how you run your business.